I'm currently the acting manager of the advocacy team. I've just been reflecting on how interesting it is to be with the Commission at this time of such change to the CCCFA. I joined the Commission in Wellington in 2003, and of course that was the year that the CCCFA came into being. I was really involved quite heavily with the set-up phase of the CCCFA between 2003 and 2005, and now looking back over all of these years, I don't think I could have envisaged such a significant change happening to the CCCFA as the introduction of responsible lending. The other changes in the Amendment Act, in a sense, are kind of incremental improvements to the existing provisions from a consumer protection point of view. As Susan said, even the new repossession provisions are broadly similar to the old CRA. But introducing responsible lending into the CCCFA is a substantial addition to existing credit law. As has been noted previously, it's a significant departure in principle from the approach of the CCCFA to date, which has tended to rely primarily on disclosure to empower borrowers to protect their own best interests when they borrow. Lenders will now be required to make judgments and take responsibility for the potential effect of the credit that they provide and the possibility that the credit might be harmful for particular borrowers depending on their circumstances. Now, we accept that most lenders probably have robust lending criteria and processes and are probably unlikely to make loans that are harmful to their borrowers. Ideally, all lenders would follow market best practice and consumers wouldn't need statutory protections. However, some lenders, in particular, don't seem to recognise that the hardship that's caused by very expensive credit provided to vulnerable consumers who have limited life choices. There's a widespread impression that some creditors deliberately target vulnerable borrowers, and to date, the law has only provided limited protection for those borrowers. We at the Commission have in the past observed and have had reported to us lending practices that cause harm to borrowers but weren't captured by the existing provisions of the CCCFA. To the extent that those practices now fall within the requirements of responsible lending, we think they'll have a real impact in encouraging more responsible lending practices and enabling us to take targeted enforcement action and reducing consumer harm. So, responsible lending is really been designed to provide the Commission also with a new set of tools so that we as the regulator of consumer credit can use these tools to protect consumers, especially those that are more vulnerable. But I think a point that's worth making really clearly is that all consumers are potentially vulnerable when they enter into consumer credit contracts. Borrowers who are on low incomes and who have few assets and for whom English might be a second language are particularly vulnerable, and they do seem to be the target market for some predatory lenders. But borrowers under credit cards, car loans, home mortgages may also be vulnerable in their own ways, and responsible lending applies equally to them. So the CCCFA doesn't distinguish between lenders to different classes of borrowers, and responsible lending applies across the board to all lenders of consumer credit. I think another point that's easy to miss is that responsible lending is consistent with other financial sector reforms, such as the Financial Advisors Act 2008, Financial Markets Conduct Act 2013. These laws impose statutory duties of care on financial advisors and other financial market participants. These financial sector laws are aimed at improving protection for consumers who are investors. Not having responsible lending would mean that the consumer credit market would be out of line amongst the financial service markets where consumers participate. The protections for borrowers provided by the new lender responsibilities are therefore similar to the consumer protections in other financial service markets. So let's turn to what is responsible lending, how will it operate under the Amendment Act, and most importantly, what difference will it make? If you like, there are two layers to the responsible lending under the Amendment Act. And I think that having the two layers has caused a bit of confusion and a bit of uncertainty in some quarters. So the first layer is the lender responsibility principles. Now they're set out in the Amendment Act. Every lender is required to comply with the principles. However, the principles are just that, they're principles. And the Amendment Act doesn't go into any detail about what lenders have to do to comply with those principles. We understand that the thinking was that lenders have their own business practices and systems, and it would be unhelpful for the Act to prescribe business practices and systems that lenders must follow. The National Consumer Credit Protection Act in Australia is very restrictive. But MB advised, and the government agreed, that a principles-based approach would be more convenient in terms of compliance for lenders and more effective in achieving the outcome of providing consumer protection. This principle-based approach is also consistent with other successful consumer laws such as the Fair Trade Act and the Consumer Guarantees Act. So the second layer, which sits in and under the principles in the Act, is the Responsible Lending Code. So the Code provides elaboration and guidance on how lenders might comply with the principles, but importantly, the Code is not binding and it's not mandatory. The principles are definitely capable of being breached by lenders, but the Code isn't capable of being breached in the same way. If a lender follows the Code, it will most likely be complying with the principles, but that won't necessarily be the case. Because the Code isn't written as a set of rules, it's simply guidance. The test for lenders will always be whether or not they are complying with the principles in the Act. One of the other features of the principles that I think is important to note is that while they will need to be complied with and can be breached, the breach of the principles is not an offence under the Amendment Act. Responsible lending will be enforceable through the court's civil jurisdiction. So courts will be able to make a wide range of remedial orders. Potentially a lender that breaches responsible lending principles could be banned from being a creditor, but lenders will not be able to be convicted or fined for breaching the principles. And that's because the principles are in the nature of legal duties rather than criminal prohibitions. Okay, so I'll just go briefly through what the principles are. I haven't included all of the text of the principles on my slides because that would make it just a very dense read, but I've just highlighted those key words that trigger the actions that are required from lenders. So the first principle is that all lenders must exercise the care, diligence and skill of a responsible lender in relation to any advertisement for credit, before entering into a credit agreement, and in all subsequent dealings with the borrower or guarantor. So this is the overarching duty, and it applies before and at all times during the life of a consumer credit contract. There's also a series of more specific lender responsibilities set out in the Act. So lenders must also make reasonable inquiries before the borrower and guarantor enter into the loan to be satisfied that the credit will meet the borrower's requirements and objectives, and the borrower and guarantor will make the required payments without suffering substantial hardship. So all lenders must assist the borrower and guarantor to reach an informed decision as to whether to enter the agreement and to be reasonably aware of the implications of entering into it. So this includes ensuring that advertising and other information that's provided to the borrower or guarantor is not misleading, deceptive or confusing, and that the terms of the agreement are in plain language, set out clearly, concisely and intelligibly. The lender must also assist the borrower and guarantor to reach informed decisions in all subsequent dealings. So, for example, to ensure that loan variations are clear, concise, intelligible, and that any other information provided is not misleading, deceptive or confusing. The lender must also treat borrower and guarantor and their property reasonably and in an ethical manner. And this is including where there are defaults, hardship or repossession. And the lender must also ensure that the agreement and any exercise of rights by the lender is not oppressive. And the final two principles, that the lenders must meet the lender's legal obligations under the CCCFA and other relevant consumer and financial legislation, and make reasonable inquiries before the borrower enters into a credit-related insurance contract, so that the credit-related insurance will meet the borrower's requirements and objectives, and that the borrower will be able to make payments without suffering substantial hardship. So what are the main points that we can take from these principles? The first point is that they create a statutory duty of care from lenders to borrowers. It's a civil law type of duty. It's actually similar, as being said, to the guarantee to carry out services with reasonable skill and care in the Consumer Guarantees Act. So in effect, it's a statutory duty not to be negligent. It won't be possible for lenders to say, well, we don't owe a duty of care to borrowers or guarantors, or to contract out of responsible lending under the Amendment Act. Attempting to contract out of the CCCFA has always been a criminal breach of the Fair Trading Act, and this will also apply to responsible lending. I think the second point is that the actions required from lenders are to make reasonable inquiries and to assist borrowers and guarantors. So to make reasonable inquiries and to assist, they're not absolute requirements where lenders are required to sort of guarantee particular outcomes. The tests are that they must make reasonable inquiries to be satisfied that the credit will meet the borrower's requirements and objectives, and the payments will not cause substantial hardship. And similarly, the test for assistance. The assistance is for borrowers to make informed decisions and to be reasonably aware of the implications of the transaction. So it's obviously possible from the formulation of the principles in the Act that the borrower's requirements and objectives might not be met, or a borrower might suffer substantial hardship despite the lender making reasonable inquiries. Similarly, a lender might provide assistance to a borrower who nevertheless doesn't make an informed decision or understand the implications of the transaction. So we think that the crucial issue for lenders is what level of inquiries will be reasonable and how much assistance is required for particular borrowers or in particular circumstances. Now, these are the sorts of issues that the Responsible Lending Code provides guidance on. So let's just turn to the code. The code has been developed by MB and was signed off by the Minister of Commerce, Consumer Affairs on the 17th of March this year, and it will come into force with the Amendment Act on the 6th of June this year. The existence of the code recognises that the lender responsibility principles are quite high level, and it might be difficult for lenders, or indeed borrowers, to be able to tell whether the principles are being complied with without some further guidance. The Amendment Act actually says that the code's purpose is to elaborate on the principles and to provide guidance on how the principles may be implemented by lenders. So we think the code is an important document, and the Commission has worked closely with MB in developing it, both through the public consultation process and behind the scenes. At the end of the day, the code is the Minister's document, and the Commission is in a similar position to lenders in that the code has been issued and it's our job to work with it. We think there's no substitute for lenders studying the code carefully and considering their business practices in light of the code. The structure of the code closely follows the lender responsibility principles in the Act, so they are clearly intended to go hand in hand. I don't intend to work through the code in any detail today. It's a 63-page document full of guidance, commentary and examples, and so we don't have time to go into that kind of detail today. What I will do is just give a general explanation of how the code relates to the principles, and then talk briefly about the sorts of guidance that are in the code, the sort of guidance that's in the code. I think the take-home message from the Commission's point of view is that the principles are where the focus lies. The code is useful, but the lender responsibility principles themselves are the most important. I'm also going to talk briefly about how advertising is handled in the principles in the code, because it's an area where the lenders that we've spoken with have taken a particular interest. So firstly, I'll just turn to the code and the relationship with the principles. As I've said, the code follows the structure of the principles, and where the code refers directly to the actual principles, it tends to say what lenders should do. So, for example, in relation to the suffering substantial hardship principle, the code provides guidance on what a responsible lender should do and elaborates on what substantial hardship means under the Amendment Act. The code says that a responsible lender should be satisfied that it is likely a borrower will make the payments due without undue difficulty, as well as meeting necessities and other financial commitments. And examples of necessities and other financial commitments are provided in the code. So this, in effect, defines substantial hardship, which actually isn't defined in the Amendment Act. However, in most cases in the code, when it comes to the actual guidance on how responsible lenders can meet the responsibilities, the code tends to refer to what lenders may do or could do. Now this is consistent really with the code providing guidance to lenders rather than specifying actual requirements. And we think in these cases the code is quite enabling for lenders. I think again that the principle about borrowers not suffering substantial hardship illustrates this point. The code reflects the Amendment Act where it says the lender should make reasonable inquiries to be satisfied that the payments will be able to be made without substantial hardship. But when it comes to talking about what reasonable inquiries might be, the code sets out a range of inquiries that lenders may make. The code also says that the scope and extent of the inquiries that might be necessary for a responsible lender to meet depends on the circumstances of the borrower and the nature of the transaction. So a responsible lender may make more inquiries in particular circumstances, but it's also implicit that a lender may make less inquiries in other circumstances. So the example I gave around substantial hardship is just one sort of example of their lender responsibility principles, and there are a number of areas where effectively there is a sort of sliding scale, both up and down, where lenders will be required to exercise their own judgments. It is fair to say that the Commission would have preferred an approach to the code that gave some more prescription and more definite minimum standards. We did advocate for that approach, as we think it would have given greater certainty in some respects to lenders, borrowers and to the Commission as the regulator. But MB took a more flexible approach. The code effectively provides suggestions for lenders, but they may have other ideas for business practices or processes that meet their lending responsibilities. Now, there are obviously arguments pro and con how much flexibility the code should provide, and our understanding is that the code tries to take a middle line. From the Commission's point of view, our approach will be to focus on the principles as setting out the primary statutory duties of responsible lenders. Obviously, we will take the code into account in evaluating lender conduct and any complaints that we receive from consumers that we investigate. But the flexibility and the options available to lenders within the code do mean it can never be a safe harbour for lenders. And to be fair to MB and to the Minister, they have consistently been very clear about this point. The code is not intended to be a safe harbour. It's worth repeating because it's important, we think, for lenders to understand that there is no substitute for making your own judgments about whether you're meeting the lender responsibility principles. By all means, make use of the code, but never lose sight of the principles, because that's where the rubber will hit the road as far as the Commission is concerned. So I'll just turn briefly to talk about advertising. And advertising is actually covered in 3 places in the principles, in the lender responsibility principles. First, it's in the overarching principle, which refers to the care, diligence and skill of a responsible lender, where it says that it applies to any advertisement for credit or finance. So effectively, lenders have a general duty to be responsible when they advertise credit. Secondly, the lender responsibility to assist borrowers to make informed decisions and to be reasonably aware of the implications of entering into an agreement refers to lenders ensuring their advertising is not misleading, deceptive or confusing. And thirdly, the responsibility to comply with other existing laws expressly refers to the Fair Trading Act and expressly to the prohibition on false and misleading statements. Obviously, that's relevant to advertising. The Code has its own section on advertising, Section 3. So, interestingly, this is an area where the Code is particularly prescriptive. It says what a responsible lender should or should not do, and doesn't refer to what lenders may or could do to comply with the principles. So from our point of view, I'd just like to emphasise 2 main points. The first is that the principles and code build on existing Fair Trading Act rules and case law that are relevant to advertising. Misleading and deceptive advertising under the Fair Trading Act will be misleading and deceptive under the CCCFA and vice versa. So the core tests remain unchanged. The second point is that the responsible lending actually adds to the Fair Trading Act tests. Most obviously, the lender responsibility that refers to advertising refers to it not being misleading, deceptive or confusing. So, or confusing clearly extends the responsibility beyond misleading and deceptive. So we think lenders will have to be more careful under the CCCFA. The responsibility to ensure that borrowers make informed decisions and are reasonably aware of the implications of their agreement also sit alongside the general duty of lenders to exercise the care, diligence and skill of a responsible lender. So the Code provides guidance on what lenders should do to meet this duty in the context of credit advertising, and the practices referred to in the Code do go beyond what has been required under the Fair Trading Act to date. For example, there are specific practices referred to in the Code about displaying annual interest rates and fees in advertisements. The Code also says that lenders advertising high-cost credit agreements should include prominent risk warnings, and if celebrities are used in those advertisements, then the celebrity should convey the risk warning. The Code also sets out examples of what responsible lenders should not do in their advertising, and many of the examples would be contrary to the key lender responsibility principles. For example, advertising instant approval or bad credit history, okay, may well indicate conduct in breach of the lender responsibility principles. Some of the practices identified in the Code as being those that a responsible lender would not engage in may also be breaches of the Fair Trading Act, such as advertising pre-approvals, which are in fact conditional, or advertising non-annual interest rates. The Commission has already taken enforcement action under the Fair Trading Act in these sorts of cases, and the amendments to the CCCFA give us new enforcement options. It's interesting that the Code says what lenders should do or should not do in the context of advertising, because the Code itself is actually not legally binding. So, for example, while the Code says lenders of high-cost credit should include prominent risk warnings, there's not an actual legal obligation for them to do so. So this is a point that not only applies to advertising, but it applies generally to statements in the Code about what lenders should do that go beyond any specific requirements in the Act. So the Commission's approach will be that the Code is a strong indication of the conduct expected from a lender exercising the care, diligence and skill of a responsible lender. lenders choosing to ignore what the code says that they should do will have to be able to explain how they're meeting their duty to comply with the lender responsibility principles. So we suggest that lenders carefully consider how they will demonstrate that they have met this duty, where they have chosen to advertise in ways that are inconsistent with the guidance under the code. I'll just finish off with a couple of practical examples, and these are real-life examples, because we think that the critical test for responsible lending will be what difference it makes in real life. Of course, this assumes compliance by lenders and effective enforcement where necessary by the Commission. But making those assumptions, I have two examples which I think quite clearly illustrate the difference that we're expecting responsible lending to make. The first one is the giving of a guarantee for a relative's loan. I'll only get the loan if it's guaranteed. It's just your name, dear. You won't have to pay anything, just your name and sign for it. This was the explanation that a mother, desperate for a $28,000 consolidated loan, gave to her daughter. The daughter agreed, having felt pressure to support her mother. When she went to the lender's office to sign the documents, the lender asked only if she was willing to be a guarantor, assuming that she knew what this meant. She didn't understand the full implications until her mother defaulted and couldn't repay, and she had to start paying for her mother's loan, which at that stage had grown to $53,000. This is an unfortunate but common scenario. Assumptions are not just made by borrowers, they're also made by lenders. So, as the law stands, this lender has done nothing unlawful under the CCCFA. The current Act simply places no obligation on the lender to ensure that guarantors know what they're signing up to. The lender would not necessarily have been put on alert that the daughter was vulnerable in terms of the current legal tests. However, under the lender responsibility principles, this lender is unlikely to have complied with its obligations. The principles place new responsibilities on the lenders to make reasonable inquiries to be satisfied that the daughter could comply with the guarantee without suffering substantial hardship, and to assist the guarantor to make an informed decision and be reasonably aware of the full implications of giving the guarantee. So the full implications of giving the guarantee would include the extent to which the debt could increase over time. We think this guarantee is unlikely to be fully enforceable under the new responsible lending regime. The second example relates to taking out a loan to buy a car. So John already had significant debt that he was struggling to repay, but he needed a car to travel to and from his job. He bought a used car from a South Auckland car dealer for $14,000. John couldn't afford to pay cash, so he signed up to a consumer credit contract with a lender associated with the car dealer. The terms of that contract included nearly $5,000 in fees and interest at 28% per annum. Over the 4-year life of the loan, John would pay nearly $30,000, and that's twice the cost of the car. John questioned the cost of the loan, but the lender reminded him of his less than ideal credit score, implying that he'd struggled to get credit anywhere else. John soon ran into problems. Given his existing debt, the weekly payments of around $140 were unsustainable for him. He soon defaulted, incurring further fees and interest, and then wasn't able to catch up. Eventually, the car was repossessed and sold for less than $5,000. So at this point, he still has a loan of over $20,000 to pay off, no car, and the prospect of losing his job. Again, this lender probably did nothing that would constitute a breach of the current law. The fees charged arguably were structured so as either not to be captured by the Act or as not to be unreasonable. All relevant disclosure had been made and the repossession was conducted lawfully. The fees might be challengeable under the ruling in the MTF case, which requires fees to be directly or closely related to the costs of a particular transaction, and the treatment of third-party fees is also likely to be different under the Amendment Act, in that we think it will be covered by the principles. But most significantly for present purposes, under the lender responsibility principles, we think the lender is unlikely to have complied with its obligations to make reasonable inquiries to ensure that the borrower will be able to make the payments under the agreement without suffering substantial hardship. In cases such as this, we think it unlikely that a responsible lender would have extended credit to this borrower without first satisfying itself that he had the ability to make repayments without substantial hardship. The consequence of responsible lending in this case would be that John would not have had access to credit on these terms, and he may not have been able to buy the car at all. However, the credit in this case has clearly left John worse off than if he had not been able to borrow the money in the first place. So those are just a couple of examples that we've come across and that we're aware of. Hopefully they give you a bit of an understanding of why the Commission supports the introduction of the lender responsibility principles. We do see them as an important new protection for New Zealand consumers that impose a minimum standard of behaviour across the industry. If the principles are complied with, they have the potential to make a real difference. And of course, as the regulator, it's our task to see that the new laws are complied with and enforced where necessary. Thank you.